Welcome to This Explainer. Today, we're diving into a massive, high-stakes legal clash over Kenya's world-famous flower exports. We're going to unpack exactly how a multi-million shilling dispute that recently shook up the logistics industry actually ties directly into everyday tax rules that businesses, and honestly all of us as consumers, rely on. So if you've ever wondered how handling a box of flowers at the airport could possibly affect the price of the bread on your table, well, you are absolutely in the right place. Let's get into it. Here's a quick roadmap of what we're covering today. First, the JKA Flower Tax Battle. Second, what the stakeholders actually argued. Third, we'll explain the destination principle. Fourth, we're going to decode zero-rated versus exempt goods. And finally, we'll look at the KRA's updated tax rules. Section 1, the JKA Flower Tax Battle. A high-stakes legal dispute. 46 million Kenya shillings. That staggering number right there is the exact amount of VAT refund claims from the 2019 and 2020 tax periods that the Kenya Revenue Authority, or KRA, initially rejected. This rejection sparked a massive legal battle with Airflow Limited, which is a major logistics company that handles cut flowers and horticultural produce bound for Europe. Airflow had applied for these refunds fully expecting to get their money back, but the KRA said no. And that hard no set off a chain reaction that went through the Tax Appeals Tribunal, the High Court, and culminated in a landmark ruling at the Court of Appeal on July 10, 2026. Now, you might be wondering, what exactly was Airflow doing to rack up these costs? Well, they weren't actually growing the flowers. They were providing highly specialized export handling services right there at Jomo Kenyatta International Airport, JKIA. It's an intense physical logistics chain. It involves cold room storage just to keep the flowers perfectly fresh, palletizing them for transport, vacuum cooling, and of course, mandatory X-ray screening for security. And here is the crucial detail. All of this was done under a service agreement for their parent company, Airflow BV, which is located all the way in the Netherlands.
Section 2. What the stakeholders argued. Two competing philosophies.
This whole controversy is absolutely fascinating because it really boils down to a clash of core philosophies. On one side, you have the KRA, who are fiercely tasked with protecting and collecting national revenue. Their argument was pretty straightforward. Because the cold room storage and the X-ray screening physically happened at JKI, inside Kenya's borders, those services were technically consumed locally. So according to them, they should either attract the standard 16% VAT or, at best, be classified as a VAT-exempt horticultural service. But on the flip side, Airflow argued that their entire purpose was facilitating international trade. They argued they shouldn't be penalized just because their operations physically sat on Kenyan soil. Because their ultimate client was their parent company in the Netherlands, they insisted these services were basically an export benefiting a foreign entity, and therefore, for sure, they should be zero-rated.
Section 3. The destination principle explained. The court's deciding factor.
So when this tug-of-war finally reached the Court of Appeal, Justices Kairu, Ongudi, and Getich had to make a definitive call on how to interpret the VAT Act. And you know what? They unanimously rejected the KRA's stance. They based their decision on something called the destination principle. Essentially, this is a legal test that says the VAT Act distinguishes between where a service is physically supplied and where it's ultimately consumed. The judges pointed out that the flowers handled by Airflow were actually already purchased by Dutch customers before the logistics services even happened at JKIA. So the economic benefit wasn't going to local Kenyan farmers or consumers at all. It was landing directly with foreign buyers. And this ruling was a total game changer for the logistics sector. The Court of Appeal didn't just clarify the law, they gave it teeth. They put a strict timeline on it, legally mandating that the KRA had to process Airflow's 46 million shilling refund within exactly 90 days. Boom. This decisively protected the financial survival of export logistics companies operating in Kenya.
Section 4. Zero-rated versus exempt goods. Understanding the crucial difference.
Okay, to really grasp why Airflow fought tooth and nail in court over this, we need to quickly decode the tax terminology they were fighting about. Let's start with VAT exempt. Now, hearing exempt sounds like a pretty sweet deal, right? No tax? But actually, it's not a total free pass. When something is VAT exempt, yes, the final good is sold without VAT added to it. However, the business making that good can't not claim back the VAT they themselves paid on the raw materials or their electricity or their equipment. The business basically ends up swallowing all those tax costs, which eats directly into their profit margins. Contrast that with zero-rated. This right here is the holy grail for exporters like Airflow. When a good or service is zero-rated, the buyer is charged zero VAT. But crucially, the business is legally allowed to claim back the input VAT they paid on their operational expenses. This completely explains why KRA's attempt to classify airflow services as simply exempt was literally a 46 million shilling problem. If they were stuck as exempt, they'd never recover those costs. By fighting for and winning zero-rated status, they unlocked their right to those massive refunds. Section 5. KRA's updated tax rules. The broader economic impact. Shortly after this massive court ruling, on July 16th, the KRA released an updated schedule to guide businesses on using their electronic tax invoice management system, or TIMS. And this is exactly where those high-level export logistics we just talked about connect straight to your everyday life. Under the VAT-exempt category, we see essentials like maize, vaccines, and solar equipment. But check out the zero-rated category. Sitting right there alongside the export supplies that Airflow fought so hard for, we find ordinary bread, LPG cooking gas, and maize flour. These everyday staples are given zero-rated status to ensure businesses can claim back their input costs, which ultimately keeps the final price lower for the average consumer. Looking at the rest of the KRA's list gives us a really fascinating glimpse into the country's national priorities. We see the standard exemptions you'd expect for agricultural inputs like fertilizers and seeds, and critical medical supplies like insulin. But here is a really surprising fact. The KRA is strategically using that coveted zero-rated status to incentivize modern technology. Locally assembled mobile phones and electric buses are zero-rated. Just like with the flower exports, the government is deliberately trying to boost these specific local industries by allowing them to recover their input taxes. So why does all of this matter at the end of the day? Because correctly distinguishing between these categories in the KRA's electronic TIM system is absolutely vital for any business. As the KRA notes, proper classification improves compliance and reduces errors. Think about it. If a business clicks the wrong button in the system and accidentally classifies a zero-rated export as an exempt local service, they could instantly find themselves locked in exactly the same kind of multi-million shilling nightmare dispute that Airflow just barely thought their way out of. Which brings us to our final thought for this explainer. The whole battle between Airflow and the KRA highlights an incredibly delicate balancing act for any nation. On one hand, the state desperately needs to collect revenue to function, but on the other hand, it absolutely has to encourage global trade to grow. So I'll leave you with this question to ponder. Does aggressive tax collection protect local revenues, or does it risk stifling the very international trade that's meant to grow the economy in the first place? It's a really complex line to walk, and as we've seen today, it's often the courts that are left to draw the final boundaries. Thank you so much for joining me for this explainer, and keep questioning the systems around you.